It's too small. We'll do it this way. All right, so Sean Grayson's family has entered the courtroom. They take their Sean Grayson is wearing a dark navy blue suit with a black and tan striped tie. He chats with Natalia Gallica, the associate defense attorney on his team. Sean Grayson's family has entered the courtroom. They take their seats behind the defense in the gallery. Donna Massey, Sonya's mother, and James Wilburn, Sonya's father, are seated in the gallery behind the state. Malachi Massey, Sonya Massey's son, has taken a seat in the gallery. Judge Cadigan has entered the courtroom. The attorneys have given a timeline for the remainder of the trial. Judge Cadigan talks to Sean Grayson about his right to testify in the trial. Sean Grayson has decided to testify. Now, this is why I wish we could watch it, because you guys know how we are, right? I think Jim Casotis might be the most recent example. Maybe Lawrence Doherty. We watched that trial as well. The shooting and killing of Adrian Payne, former NBA player. That moment where it's like, are they going to take the stand? And then the defendant actually says yes. It's always like a moment. So Sean Grayson decides to testify. The state rests their case. Mr. Fultz has called Sean Grayson to the witness stand. So defense, that's their first witness. Fultz is now questioning Sean Grayson about his experience in policing. The Sangamon County Sheriff's Office sent Grayson to a 14-week training program with Macon County law enforcement. He also did 2 weeks of in-house training. Sean Grayson shares an average day as a deputy on the first patrol shift, 11 p.m. to 7:30 a.m. During the shift, a deputy can expect to receive calls concerning shootings, stabbings, bar fights, and domestics. Grayson usually patrols Northtown, everything north of Cook Street in Springfield, because again, we're over in Illinois. On the morning of July 6, 2024, he was assigned to patrol Southtown, south of Cook Street, almost down to Chatham, Illinois. Sean Grayson says he did not work with Deputy Farley on a regular basis. He's only worked with him 5 to 6 times. Now, maybe that's an important detail, because Deputy Farley, who was the only other person that's still alive that was in the room when the shooting took place, he testified. He said that he didn't think that Sonya Massey was a threat, and that if anything that was worrying him, it would have been that his partner in that moment, the defendant Sean Grayson, had outside of protocol stepped forward in the moment and gotten within like the line of where Farley was standing to where he would have been in the clear to have a view of Sonya Massey. Basically got in the line of where Farley had his weapon drawn. And Farley only drew his weapon drawn because his partner had drawn his weapon. So now we're hearing, well, they weren't really that close. So maybe Farley doesn't have such a good read on what Grayson could have perceived in that moment. On the morning of July 6th, Grayson was working a traffic stop. He forgot his new computer system, so he wrote out a physical report. He received a call saying that a woman, Massey, had called 911 about someone outside her residence, but the call was disconnected. Sean Grayson left the traffic stop and arrived at Massey's residence at the same time as Deputy Farley. Grayson explained that Massey lived in the Cabbage Patch area of Springfield, an unincorporated area in the east side of Springfield known for high crime. Sean Grayson. And the reason they're pointing this out is because they want the jury to, I would imagine, the defense's strategy is that they want the jury to see themselves in someone's shoes who knows they're going into an area where things get heated. On Friday, we had an expert witness take the stand who likes to look at what practices are currently in place, what procedures are currently in place, evaluate them, and see if there's room for improvement. And maybe there should be specific protocols in place that reduce knee-jerk reactions, quick reactions in areas where someone might naturally feel inclined to be on a heightened alert. I don't know. Just food for thought from me. Sean Grayson says, when we are doing something that is not civil, we have to have our body cameras on. When Massey, answered the door and started questioning her about the car, and I started questioning her about the car and the damage to the car, is when I should have turned my body camera on. Grayson says he tried to turn on his body camera when he saw the car in Massey's driveway. He said he didn't double check that it was on, though. Most on the night shift turn the lights off and mute their body cameras so as to not alert anyone. Now, we're only getting text updates, but we had someone talk about procedure and policy. We had people from the department talk about the policy they follow in the same department that Grayson works. I don't remember seeing a detail or any reporting that the defense got up there and cross-examined any of those witnesses to ask if this was procedure. And unfortunately, I might be holding that conclusion right now that, well, you're only letting your own client discuss this. It could be more compelling if somebody else said it. Maybe they asked that and ABC 20 didn't make a tweet about it. Or maybe they didn't ask anyone else about that and we're giving a justification here. So this is kind of the difficulty of reading rather than being able to watch the whole thing. And that's no shade to ABC 20 here. Grayson explains the layout of Sonya Massey's yard and how he and Deputy Farley split up searching the premises. Sean Grayson and Sonya Massey's family stare right at Grayson as he testifies. The jury stares at him intently, occasionally taking notes. Sean Grayson says he told Deputy Farley to tell dispatch to call Sonya Massey to try to contact her after she failed to answer the door. He said he was worried someone had made it inside her house. Sean Grayson, this is a quote here. Her, meaning Massey's, behavior was pretty typical for people we deal with on Monday nights. What? Is that saying like but this was July 4th weekend and things be going on. I don't know how Illinois is, but at least in Florida, which is probably an exception. July 6th is still July 4th in Florida. So I don't know. I don't know what that means. Sean Grayson says Massey kept saying she wanted help with something inside her house. Grayson said he'd come inside, but he needed her name, so he asked for her license. So they didn't know her? How did he tell them? Maybe the instruction was to call back the caller, but the caller was unknown when he gave this instruction. But it's unclear if ABC is using Sonya's name here to tell us that it was Sonya, or if Grayson was aware that it was Sonya when he told Farley to call dispatch and say, try to call Sonya back. Or was it just call that caller back, see if you can return the call to that caller? Because otherwise this wouldn't make sense. And again, this is the struggle of reading it rather than seeing it. So Sean Grayson says Massey kept saying she wanted help with something inside her house. Grayson said he'd come inside, but he needed her name, so he asked for her license. After running the car registration, Deputy Farley told Grayson the car was in Sonya Massey's name. Okay, so this is where they're getting the name. When Grayson stepped into Massey's house, he noticed a baseball bat in the living room next to her Bible. He said he just assumed she had the baseball bat to scare anyone off. Grayson did not realize there was water on the stove when he initially stepped into Massey's house. Grayson asked Deputy Farley to search Massey's house to ensure there were no other patrons in the household. Sean Grayson described Massey as being cooperative as he questioned her. Grayson saw the pot on the stove turn red. He looked at Deputy Farley and said, "Go check on her stove," with the expectation that he'd just turn off the stove. Grayson says Deputy Farley was closest to the stove as Grayson was positioned between Massey and the baseball bat. Grayson said he was concerned when Massey jumped up and went behind Deputy Farley and walked into the kitchen. Massey turned off the stove and picked up the pot. Grayson was concerned because he didn't know what Massey was doing. Grayson said Massey turned on the sink but didn't use the water. Grayson and Deputy Farley started walking back away from Massey. Massey asked, "Where are you going?" And Grayson said, "Away from your hot steaming pot of water." Grayson took Massey, saying, "I'll rebuke you in the name of Jesus," as a threat. Grayson stands up to demonstrate to the jury how Massey was holding the pot of water. And we don't have a description of that. Grayson says he was trained to use force to gain compliance. He says he matched Massey's threat level by drawing his gun. Fultz asks why a taser was not appropriate defense against the pot of water. Grayson said he had an older model taser, and Massey was wearing multiple layers of clothing, which could have made the taser ineffective. Grayson didn't want to risk the taser not working. So I don't know much about this stuff. And she was in more than one layer, but it was like a thin, silky robe. Or at least like that type of robe to me, it comes off as very thin. So I don't know if that would still apply. But he didn't want to risk the taser not working. I have a problem with this because if you are aware, if you are in the moment and you don't feel comfortable relying on your taser in a moment that ordinarily you would rely on the taser or might want to be able to, and maybe there's like discretion and you want to lean on one side, if you're already fearing that your tool that you're supposed to carry with you to use as part of protocol isn't working, do we have a report that you have an issue with this equipment? Or are you just relying on that now as a fallback? Like get a new taser. Go in Fulton County. This is the one thing Fulton County would actually make sure they took care of. They would go take the funds that are meant for, inmate care, and they would go get a bunch of honey baked ham gift cards, real thing, bounce houses for staff parties, real thing, and a bunch of tasers. This is what the DOJ found out when they did their report on the Rice Street facility. That's what they were using funds meant for the inmates on. But here we're not getting new tasers. Did we report this though? Did we report this? That's Pierce's taser and water seems sketchy. That's where I thought this explanation was going to go, but I don't know any better, right? You would think electric and then pot of water. You don't want to use taser, but that's not what he's saying here. That's where I thought this was going to go. Let's keep going. Let's see. Grayson said he approached Massey because he was trying to secure Massey in handcuffs for aggravated assault on a police officer. What? For holding the pot and making threats. So we heard, we get this expert on the stand that says, look, you have time in your favor. Time is away, distance is away. These different characteristics of what's going on in a moment where things can change in an instant. Being able to have extra time to make a decision or make a move. Being able to have extra distance away from where there could be a threat where someone could have an opportunity to harm you. Creating distance is good, and his evaluation of the circumstances here, he concluded that Sean Grayson, in stepping forward, decreased the distance, which was against protocol, which is it seemed like he was saying it was against common sense. And now it seems like Grayson in this is being typed almost as like a narrative, but we know Foltz is doing direct examination. Grayson gives a reason. He says, this is why I approached. Because I was trying to secure Massey in handcuffs for aggravated assault on a police officer for holding the pot and making threats. I didn't hear any of that announced on the body cam. And his partner, Deputy Farley, his body cam was running, right? We have some audio from Farley's body cam, even though Sean Grayson's was not turned on at the time. I personally do not remember anything mentioned about like, we're going to take you into custody because you are holding a pot of water. So I don't think this is good. I would take a note as a juror if I heard this. Grayson said he also approached Massey to get a clear picture of what she was doing behind the cabinet. And let me go back. I think this is the danger. Maybe in this case, he has to testify to let the jury know his side of what he was perceiving in the moment, because Deputy Farley, which I think is kind of rare, we have testimony from another officer saying, you know what, I don't think my partner's actions were justified. I think he stepped out of bounds. I think he was the one that made me worry. So kind of in a position where Grayson's got to go up there. But this is stepping on a rake. Stepping in a rake, I think. Grayson said he also approached Massey to get a clear picture of what she was doing behind the cabinet. So you're already approaching her to try to arrest her, but you also need a picture of what she was doing because you're not sure. But you already made the determination that she was committing aggravated assault for holding this pot. So you either see it or you don't. And this all took place in like a few seconds. I don't know. So he says he's trying to get a clear picture. After Grayson said, I'm going to shoot you in the, and he says fucking face in the body cam. It's censored here. And Massey said, okay, I'm sorry. Grayson felt he had gained compliance. Grayson saw Massey grab the pot, raise it above her head, and throw the pot at him. Grayson said he only discharged his weapon when he saw Massey throw the pot at him. No further questions from Foltz. Millhiser, this is the prosecutor, approaches for questioning. Millhiser shows Sean Grayson the reports he wrote. Grayson didn't write in his report that he said he would shoot Massey in the effing face. You know what? If you guys are okay with me taking a pause, I swear I downloaded this and I couldn't find it the other day. But there is a contrast with his report compared to every other officer's report from that day. Dun, 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 dun. Got all these documents here from the Alicia Andrews trial. Let's see if I can find it in. Sorry in advance. I need a moment here. When did we start talking about this? I think I looked it up the day before I did the first stream. Let's see. I think what happened is I found the PDF was online and I just didn't download it. I just didn't download it and keep it in my downloads. I saw it embedded in an article and never actually clicked the download button. Which if I'm pulling it from a docket, I'm going to download it. Out of habit, I have it on my downloads. Maybe I'll find it. Maybe I'll find it tomorrow. Give myself that homework because I don't want to waste too much time looking here. But the incident report, it was like over 20 pages long, I think. And it had different reports from everybody who was there. And Sean Grayson's was like the shortest one on there. So about the report you wrote. Grayson didn't write in his report that he said he would shoot Massey in the effing face, so you left that part out. Millhiser emphasizes that if Deputy Farley didn't have his body camera on, nobody would know Grayson said that. Millhiser has no further questions. Oh, and it's hard to tell if it was really that short or if that's what we get as notation here, but it seems like a short cross. We went with the sassy mic drop. Let's see. So Foltz redirects. We have Grayson. Grayson didn't feel the need to write everything down in his report because it was all shown on the body cam footage. I mean, that kind of emphasizes the point. Like, I agree. But it was because your partner had it on, not because you. You told us that you didn't have it on because it's practice that at night you leave it off to go undetected, and you didn't double check that you turned it on when you thought you turned it on. So, but we're redirecting. Foltz asked Grayson if he ever went to the Illinois State Police after he filed his initial report to charge his story. I think that's supposed to be change his story, alluding to Deputy Farley's actions. Grayson says no. So remember, Deputy Farley said he went and he wanted to give more context, and I don't know if he necessarily changed what was already in his report, but he made a change to the report to add additional details, and he said he felt like he needed to do the right thing. Foltz and Millhiser both have no further questions for Grayson. They're on a break. So Judge Cadigan and the jury have re-entered the courtroom. The defense has called Sangamon County Deputy Jason Eccleston as their second witness. Wyckoff's, this is defense doing direct examination, asked Deputy Eccleston to share what he saw upon arriving at Massey's house the morning of July 6, 2024. Deputy Eccleston and that's going to mess me up. And Grayson appeared panicked. So Eccleston says Grayson appears panicked. Eccleston took Grayson to his car. Grayson started sobbing in the car. Eccleston told Grayson to calm down. When Grayson was in Deputy Eccleston's squad car, his demeanor was up and down. Eccleston shares that he knows Grayson quite well and that his demeanor was not how Grayson usually presents himself. Rogers for the state cross-examines him. In Deputy Eccleston's report, he advised Grayson not to speak to anyone. Rogers says Eccleston said, "Don't say an fucking thing to anyone." And then he told Grayson to turn off his body cam. Oh, I wonder if this was challenged. I wish we could watch this because we have the prosecutor. It sounds like the prosecutor in their question is saying something to the effect of, "And in your report, did you say," and then they recite it. And maybe we don't get a cooperative answer. And remember, the questions aren't supposed to be evidence, but the jury hears it. I would love to see how this interaction actually happened in the courtroom. But I don't think, unless the jury has the impression of Rogers as being like a shady clown ball attorney, the question itself could be really impactful. But I don't know. In Deputy Eccleston's report mentions that it's written weird. So his report mentions that his encounter and Grayson's demeanor were recorded on Eccleston's body cam. Rogers emphasizes that Eccleston told Grayson to turn off his body cam, and Eccleston turned his off. So Grayson's demeanor wasn't captured on camera. Oh, well, I think this is very strong for the state. Kind of more towards Eccleston's behavior. This is the difference, right? That's why I said earlier it was a bit unusual that you have Deputy Farley specifically, going in and saying, like, "No, I don't think what my partner was doing was justified." And then now you're seeing a different deputy who gets there after the fact, like, "Turn off your body cam. Turn off your body cam. Don't talk to anybody." And I'm not going to shade anyone for saying maybe you should get a lawyer and wait to speak to anyone until you get a lawyer, or maybe your union rep or something, since we're dealing with law enforcement officers working in their duties. But it seems like he didn't want to answer. I'm visualizing this as being Eccleston didn't want to answer, said he didn't really recall. And so we get to reinforce it. We get to say, well, right here, this is what happened. And then his body cam shuts off, right? That's how I'm visualizing this. Yeah. I mean, I think that's a spade is a spade moment. But yeah, so Eccleston turns off his camera. Grayson's demeanor is not captured on camera. So what about before this advice, though? Was he already crying before this advice was given, and is that captured anywhere or no? So Wyckoff redirects and reiterates that Deputy Eccleston can still testify to Sean Grayson's demeanor. So no further questions from either side. Yeah, what do you guys think of, like, the defense redirecting and saying, well, you can still testify, even though we don't have the footage, you can still testify? Do you necessarily think that the testimony can overcome, the absence of the video? Maybe in normal circumstances, but I think a good amount of people would think that turn off your body camera, coming from someone in a situation where you might, if this was a regular citizen, do you think the deputy would have advised, hey, stop recording on your own phone? If you're recording me, stop recording what you're doing. Do you think this deputy would have turned off his own camera or advised his colleague to turn off their body camera if it was the two of them questioning a citizen? Because that's what makes this a credibility issue. So there's no further questions there. The third witness called by the defense is Coweta County Sheriff's Office Sergeant Glyn Corbitt. Corbitt owns a consulting and training company that consults on use of force cases. Wyckoff asked Corbitt about his experience at the Georgia Public Safety Training Center as a manager and trainer. Okay, so I wonder if this guy, because we heard that Sean Grayson was over in Macon County for a while. So this trial is Illinois. But I wonder if this Corbitt somehow did some training with Sean Grayson, and Macon County, because we're talking about Georgia now. But they're at the Georgia Public Safety Training Center. We're back in Georgia. Corbitt says the Georgia Public Safety Training Center follows generally accepted practices and best principles in law enforcement, best practices in law enforcement, and that he managed the Crisis Intervention Training Unit. Corbitt has experience testifying as a use of force expert in criminal trials. Corbitt has been declared an expert on use of force. Wyckoff asked Corbitt about his report on the case. Wyckoff asked whether having a copy of the law enforcement agency's use of force policies is a fundamental component of conducting a use of force investigation. Corbitt says yes. Corbitt says, upon reviewing Sangamon County's use of force policy, he believes it falls within the generally accepted principles and best practices. Corbitt says when examining the case, he didn't think Grayson acted out of line based on the policy. Corbitt says Grayson approaching Massey falls within the generally accepted principles and best practices, and that it's not uncommon for an officer to get a line of sight of a subject. Meaning this is why it was okay for him to move closer. Because there was like, if you didn't see the video, there's like an island counter that divided like where the living room space was and the kitchen area. Corbitt describes this as a perceived threat. If an officer loses sight of that threat, they don't know what could happen next. Wyckoff explains that there were two conflicting, generally accepted tactics, keeping a line of sight and creating distance between you and the subject. So that's important for the defense. Contradict the other expert that was called and say, well, there's two conflicting, generally accepted tactics. They conflict, but they're generally accepted. You can do this or you can do that. And the last expert was inclined to the creating distance idea. This expert's going to emphasize that keeping a line of sight is another viable tactic, although it conflicts with the other tactic. Corbitt says you have to, quote, try to pick the one that's best for you and your partner. Well, we had the partner say that this tactic wasn't the best decision. Corbitt says Grayson choosing to keep a line of sight on Massey was the right decision. Corbitt says there's a misconception about what de-escalation means. It's different in the law enforcement world compared to the public. Corbitt emphasizes that de-escalation isn't just verbal communication. Wyckoff asks whether it is a generally accepted law enforcement principle that the receiver's, Massey's actions, often escalate the event. Corbitt agrees. Wyckoff asks if Deputy Farley had turned off the stove when Grayson asked him if that could have possibly de-escalated the event. Corbitt says, at that moment, I didn't think there was an event, but that would have prevented an event from happening. So blame the other guy. Corbitt says Massey's grabbing the pot escalated the event, and that if Massey had put the pot down and poured the water out into the sink, it would have de-escalated the event. Rogers objects to leading questions. Wyckoff rephrases his question. Corbitt concluded that Grayson tried to de-escalate the situation. He says that the crisis intervention perspective of the situation changed to a use of force incident due to a perceived imminent threat, given the totality of the circumstances. Corbitt says the facts perceived matter when creating a report, and that Massey's intentions with the pot don't matter at all. Only the officer's perception matters. Yeah. Well, there's subjective and objective reasonableness. But there's a little issue here. Corbitt says the facts perceived matter when creating a report, and I'm telling you guys, Sean Grayson, his report was like a third of a page. That was his report. So not much detail there on what he perceived, except he did state that he felt he was in fear for his life. Corbitt determines that Grayson's use of force was appropriate, drawing on his years of experience and training, and recognizing that officers must make difficult decisions and are not robots. As a use of force investigator, Corbitt says you have to conduct analysis objectively and shouldn't look at it through 20/20 hindsight. I really think that we should all be aware of this, right? When we're able to pause things, when we're able to say what we would have done in a situation when really we weren't in there. I really do think this is a true principle. And I think a lot of these cases, sure, this happens to involve a law enforcement officer. So they're looking with a lens at policy, procedure, best practices. In any type of self-defense case, when the jury's asked possibly a split-second difference between something being not justified to suddenly it's justified, it became justified in that moment. I do think it's important, no matter what side of the aisle in the courtroom, to be aware of 2020 hindsight. So I will certainly and strongly agree with this principle here. Wyckoff has no further questions. We will continue with the state's cross-examination after lunch. So they take their break. Rogers does the cross-examination of Corbitt. Rogers approaches Corbitt with a synopsis he has written of the case. So Corbitt wrote a synopsis. Rogers questions Corbitt about his definition of de-escalation. Corbitt agrees that it would be ideal if de-escalation could be achieved through verbal communication, but that's not always the case. Rogers asks Corbitt in his synopsis or a full report on the case how many times he uses the terms, quote, generally accepted principles or practices. Corbitt doesn't use the terms at all. Corbitt believes Sean Grayson achieved de-escalation. I mean, technically, Rogers, quote, you believe shooting Sonya Massey in the face was successful de-escalation. Oh. Corbitt says yes. No further questions from the state. This guy just gets up there and just goes, whoop, whoop. And drop a little mic there. Wyckoff redirects, and I'm saying that because, all right, maybe in the academics here, de-escalation involves whatever you got to do to stop a threat. But I think I think as a layperson, I don't think of de-escalation, even though it quite frankly put an end to the event. I don't think of de-escalation including an escalation before the de-escalation happens. If that makes sense. Just as a layperson, how I would use that word, that's not how I would use that word. Wyckoff, oh wait, we skipped that, right? All right, so Wyckoff redirects by confirming that although Corbitt doesn't address generally accepted practices in his report, they are implied because Corbitt's training and analysis already follow them. No further questions from either side. All right, so Judge Cadigan asked the attorneys to approach for a quick conversation. The next witness called by the defense is Kevin R. Davis, a retired law enforcement officer who worked in Akron, Ohio. Davis runs his own consulting and expert witness firm. Davis has been declared an expert in the use of force and in use of force investigations. Wyckoff asked Davis what conclusion he reached based on the materials he received, including the Sangamon County use of force policy. Davis says he believes Sean Grayson's decision to employ lethal force was warranted. Sean Grayson fidgets, touching his face and looking around the room. Davis says the totality of the circumstances analysis ends once the force has been applied or is no longer being used. Davis says what happens after that is irrelevant to the conclusion one draws in a report. Davis says de-escalation is a concept that has gathered steam within law enforcement over the last few years, establishing that the use of force is unnecessary in some situations. Well, we kind of just had the expert before you say use of force is a part of de-escalation. And now I would interpret this statement that Davis is giving that de-escalation is a contrast, an alternative to use of force, which is my layperson, how I would look at the word de-escalation in any other context. So to me, that's a little bit of a conflict between your two experts there. But maybe you think that's helpful because, again, the expert that the state called that we heard from on Friday was like, look, none of this is definitive. And we don't want it to be definitive. We want it to evolve. We look at what's generally in use rather than calling anything a best practice, because we don't want to create that hierarchy that something is the right thing, definitively the right thing to do as a best practice. We don't want to call things best practices, right? That's what the state's witness stated. So, yeah, I mean, that's how I like we're including in the first, so we have state's witness, we have two expert witnesses from the defense. The defense's first expert witness on use of force is including escalation as a de-escalation tactic, is the way I'm looking at it. So Ghost, I'm with you. Like, that's expert one for the defense is saying it's part and parcel. And again, that's the guy from Georgia. That's the guy from Georgia coming in and saying that. Oh, man. Let's see. Back to defense's expert two on use of force. Davis said Grayson made attempts to de-escalate the situation, particularly when Grayson asked Massey to put the pot of water down. See, that's what I would look at as a de-escalation attempt, put the water down. Wyckoff asks if it's a generally accepted practice or principle that an officer should create distance between an armed subject for self-preservation. Davis says yes and no, and that a tactic is dependent on circumstances. Davis says Grayson's decision to walk towards the counter was to allow him to see Massey's movements, and thus was not a tactical blunder. Wyckoff plays out a hypothetical. An officer can violate a tactic, violate a CIT policy, and violate a de-escalation policy, but still be within the confines of the use of force policy, deploy use of force, and be okay to do so. The body camera position won't capture what an officer directly saw. Well, I mean, we didn't have the angle from, but the argument there is even if we had the body cam on Grayson and it was like shooting from this area, it's not going to reflect what the vantage point from here was. What the vantage point, if I'm turning my head, but my torso is still affixed forward, right? Problem with that is up to the point anyway, there was quite a long time where we wouldn't have had that body cam footage anyway because it was turned off. So Davis emphasizes that the cameras are only one form of evidence and that they are equipped with a fisheye lens that distorts distances. Davis also extracted individual frames from the body cam footage, as Illinois State Police did. He came to the same conclusion as ISP. Davis says, the video is the video, the evidence is the evidence. Davis explains officer-created jeopardy, a notion he claims shifts responsibility from the subject to the officer. The idea is not generally accepted in police training throughout the U.S. And I think this is the ultimate question, right? The defense is trying to establish that there's, different decisions that an officer could make, that even though they might contradict, the philosophy of what someone else would do in the situation, that they could be acceptable. But now I really think what the jury is going to have to get at is, was this de-escalation? Was this officer-created jeopardy in these final moments? Davis explains officer-created jeopardy, a notion he claims shifts responsibility from the subject to the officer. The idea is not generally accepted in police training throughout the U.S. And this is where maybe it should be. Maybe it should be. I'm surprised. I'm not surprised, but I am surprised that it's not. If we have all these experts coming in and they're trying to teach departments on how to do their job better in safer ways that can lead to better outcomes for all involved, I would think that this would be, even in the last few years, as de-escalation is increasing in relevance, right? These departments are trying to learn it, whether for good reasons or just to avoid lawsuits, make the city happy, whatever the reason may be. You would think that this would be a necessary part of it. So that's kind of weird to hear. Well, we just don't talk about officer-created jeopardy typically in police training throughout the United States. I think we should. I think we should talk about that. If I was an officer, if I was Deputy Farley, and I felt like my partner, Grayson, who's young, who shifted departments a lot, made me worry, I'd want my department to say, like, hey, we need to do some officer-created jeopardy training. Because Grayson, you shouldn't be, when your partner draws his firearm because you've drawn yours, as he's supposed to if you've drawn yours, you then don't step in front of him while he has his handgun withdrawn and pointing. You don't do that. That's you creating a bad situation for you and your partner and others in the room. I think we should have that training. I think we should have that training. Anyway, I digress. So Wyckoff has no further questions. They take a short break. Judge Cadigan and the jury return to the courtroom. Millhiser for the state does cross-examination. So, Millhiser questions Davis about his blog and different blog entries. Millhiser argues that Davis's blog advocates for the use of force in policing. Davis disagrees. Oh gosh, do we have to look up the blog, guys? What's this guy's full name? Now, I'm going to highlight the one we're on. Davis, Davis, Davis. Uh, Kevin R. Davis. Kevin R. Davis. He's got a consulting firm with a blog. So maybe some good reading tonight, guys. Oh, I highlighted it, right? All right, it unhighlighted, but we were here. So he's questioned about his different blog entries. Davis is reluctant to say that his blog advocates for the use of force in policing. Millhiser asks Davis about the report he wrote on the case and notes that there is a lot of cut and paste from other professionals' reports. Millhiser reads quotes from Davis's report. Quote, "We must examine Massey's manifested intent by way of her actions." Quote, "His," meaning Grayson's, "small movements did not create the jeopardy that led to the shooting." More from Davis's report. Quote, "An officer under attack by a female subject with a pot of boiling water." Then Millhiser emphasizes that the statement sounds pretty bad and that it's a good thing there's body cam footage of it. The state is through with questioning. Wyckoff redirects. Davis says he followed generally. Oh my God, guys, it's happening again. So I don't know. I'm on a hot spot. We had terrible storms yesterday. It was raining a little bit like an hour ago. I could hear the thunder rumbling, but we were good. Um, I have the little thing. I'm on a hot spot. I see that I'm getting like the speed warning. So I don't know if I'm jumping around, but we're only sharing text. We're not sharing a YouTube video. Maybe we can make it through these final tweets. We're gonna try. We're gonna try. Touche is here to save the stream. Hello, Touche. Yeah, this is the wind blew the internet again. And I don't know. The hotspot was the 5G was a great solution last year. Haven't tapped into it in like a year. I don't know if I need to like troubleshoot the device or what. Hopefully it holds out for the rest of the stream. We only have a little bit of a ways to go. Oh man. Look how long it's taking to load this little. We're gonna do it. We're gonna do it. The cops cut out my internet. Oh man. I will always come back, guys. If it jumps out, sorry if I came back in screaming. If the power goes out, my internet goes out, unless my phone is dead, I will jump on my phone and jump in the YouTube chat and let you guys know what's going on and if I'm powering back up or if it's just like a no-go for the rest of the stream. I'll always try to let you guys know. So there we go. We were here somewhere. Oh yeah, this thing, I will read a few in case it cut me off earlier than I think. But we had more from Davis's report. This quote, "An officer under attack by a female subject with a pot of boiling water." Millhiser emphasizes that the statement sounds pretty bad and that it's a good thing there's body cam footage of it. The state is through with questioning. Wyckoff's redirecting. Davis says he followed generally accepted practices and wrote his report neutrally, dispassionately, and without bias or preconceived notions. Wyckoff brings up a book Davis wrote and asks him to count how many times he cites himself, referring to expert witness Seth Stoughton. Wyckoff says, "Is it safe?" And so what Wyckoff is referring to is when Stoughton was on the stand, this was something that they pressed Stoughton about. Like, you cite yourself a bunch, you think you're like the bee's knees. So Wyckoff says, "Is it safe to say that because you didn't cite yourself in your report, you're not here to generate book sales?" Oh, is it not going to load? Oh, wait, I can just pull it up on my phone. And I can read to you guys like a true, we're approaching, it's 9 p.m. It's bedtime story hours. I can just read them to you guys. So they might not be on screen if this doesn't want to load, but let's see. Let's go over to ABC. We're going to make it work, chat. And I'm gonna cry if I wake up tomorrow and have to tell you guys, like, hey, the internet's doing the internet thing again. Um, all right. Wix ABC 20, day 6. It has been a day. All right, let me scroll all the way down. Uh, all right, I'm at the part Wyckoff brings up a book Davis wrote. All right, so redirect is done. The state has no further questions. The defense rests. Court is done for the day. So all that loading, and we're just getting to the court's done for the day. Let's see if they talk about jury charges. Um, okay, we will be having a jury instruction conference after a short break. Judge Cadigan has returned and called for a short recess. He left the courtroom. Judge Cadigan has returned. The judge and attorneys are having a jury instruction conference. There was deliberation over the wording of the People's Instruction number 19 from the defense, but Judge Cadigan overruled it. We don't have info on what that instruction was. Now they're going over the defense's request for instructions. We are going through the defense's instructions. The attorneys have approached for the sidebar. Judge Cadigan asks if Sean Grayson is aware that second-degree murder was included in the jury instructions. Grayson says he understands. We're done for the day. We will be back in court at 9 a.m. tomorrow to hear closing statements from the state and defense. So it seems to me like the defense might have, let me reread this again and see if you guys get what I'm pulling from this. They state, we are now going over the defense's instructions, what they're requesting be instructed to the jury. They approach for the sidebar. Then Cadigan, after the sidebar, Cadigan asks if Grayson's aware that second-degree murder was included in the jury instructions. So I wonder if that was a request from the defense. And that's why they need Grayson's consent for the defense's strategy, right? Because I don't think Grayson would have a say in what the state was charging him with. He could file a motion and challenge the, sufficiency of the charge or something. But they're done for the day. We'll be back in court at 9 a.m. tomorrow to hear closing statements from the state and defense. All right, so that wraps up that thread. We got it done, chat. What a day it has been. We will, of course, look for the updates and see ABC's reportings on the closings from both sides and anything notable that happens with jury instructions. And then they'll go into deliberations over there. And of course, even if we're streaming Alicia Andrews, if there's a verdict in that and we're live talking about Alicia Andrews, we'll pause and go read the news. I don't think there'll be cameras for the verdict because there haven't been cameras at all. But we'll pause and go read the reading that's reported.